Important to place on record that both the plaintiff and the Attorney General have complied with these orders, and this court is able to complete hearing of this suit if the Speaker chooses to file no processes. For the above reasons, the application is refused. Not even the President and Vice President are exempt from obeying the orders of the Supreme Court when they are made to give effect to its duty to prevent a violation of the Constitution. Because of the irreparable harm to the constituencies made up of hundreds of thousands of Ghanaians who would have lost their MPs without the option of a by-election, and the irreparable harm to the MPs who would have lost their seats in Parliament in these last few weeks to the 7th December elections.
Chief Justice, I reject Alban Bagbin application now of file called Supreme Court. No, I have a Mago Life Media. Subscribe and like and share you know for my for on America Crane no MPs be equal independent and pay a constitution no na was say speaker announce your seats no say a vacant na eno mo no na NPP who say there be and yes na constitution no at tie anasa se it's what the call Supreme Court and back and forth. Now speaker say we dissolve parliament until so no be free. Ni na no back and forth no and verdicts no every Supreme Court aba a Chief Justice then no din sim matudwa yanko na yanko hwe nyema ni bia course so e wo ye Supreme Court ene
arises from some of
to that my lord on the stream what
right to my lady the Chief Justice, to him being impaneled in this matter arises from the fact that at a point in time he was known to be associated with the New Patriotic Party. And in fact, he was a parliamentary candidate in one of their constituencies in the Volta region.
I think you said enough.
Very well. And
yes.
I just want to demonstrate from, especially again.
No, I think you said enough.
From the
I think you
proceedings
said,
and the
no, I think you said enough. Kindly resume your seat.
Very well, my lady.
Let's go.
No. This is like just case
Registry.
My lords, with respect,
you gave your privilege of please stand. You gave your privilege of addressing the court to your junior, so we will not hear you, not on these matters.
my lord,
we will not hear you.
I apologize. I was sitting in Parliament. When the speaker is talking, you sit, you don't stand. So when I make this mistake, accept it. And my junior,
Please, Mr. Gatti, we will not listen to you at this point.
okay. When you are ready, when now you decide that you are.
Mr. Gatti, we will not listen
I'm just
to you.
saying that, my lord, if
the
you
court
decide,
will rise now to give a.
then you.
All rise.
All it says is that civil or criminal processes coming from any court or place out of Parliament shall not be served on or executed in relation to the Speaker or a member of the of the clerk of parliament while he is on his way to attending at or returning from any proceedings of parliament. In my respectful view, I do not see Monday in Article 112, 117. I do not see Monday there. I do not see Tuesdays to Friday. I do not see. All that must be understood clearly. Irrespective of that circular, in my respectful view, I, the Attorney General, can, or any citizen of the land, having invoked the decision of the Supreme Court, can serve the process on a member of parliament, a speaker of parliament, or a clerk of parliament, except when he is on his way to parliament or returning from parliament. That's what it says. But again, there is an attempt to suggest, and it was implied in the submissions relating to the Supreme Court overstepping its bounds and what have you, that Parliament of Ghana,
I know I have a right to reply, but it's done over 25 minutes. Yeah. Let me we've been checking.
Attorney General, you have 1 minute left.
But I know I have a right to reply, especially that he got up only on points of law. So but he's exceeding.
Please sit down.
Yes, the point of law I made it because the application.
Please don't waste your 1 minute.
But I'm afraid. But the point I'm making is that the Supreme Court's judicial review powers, pursuant to Articles 2 Clause 1 and 130 Clause 1, extend to any authority, institution of state, or any individual in the country. No arm of government, no institution of state, and definitely no individual is exempt from it. Indeed, the President himself is even subject to Supreme Court's judicial review powers under the Constitution. And the Constitution spells out the consequences for a failure to obey decisions and orders and directives of the Supreme Court. That is in Article 2, Clause 4. Failure to obey or carry out the terms of an order or direction made or given under Clause 2 of this article constitutes a high command under this Constitution and shall, in the case of the President or Vice President, constitute a ground for removal from office under this Constitution. So clearly, the powers of the court can never be questioned at all. And it is for this reason that the Supreme Court, to follow an Attorney General and further fortified by J.H. Mensah and Attorney General, reported in 1996 Supreme Court of Ghana law report, stated clearly that in Ghana there's even no such thing as a political question. The court can call into question any act or omission of any person at all, insofar as it's in violation of the Constitution. So the contention by my left friend, Counsel for First Defendants, that it was an administrative decision of the Speaker, and so with all respect, I'll ask, and so what? Any administrative decision of a person or authority which comes in contravention of the Constitution is amenable to the court's judicial review powers. I certainly submit that the application before you is totally offensive to all rules and procedure of this honorable court, is unknown to the laws of Ghana, and must be dismissed. I pray accordingly.
Not even the President and Vice President are exempt from obeying the orders of the Supreme Court when they are made to give effect to its duty to prevent a violation of the Constitution. Because of the irreparable harm to the constituencies made up of hundreds of thousands of Ghanaians who would have lost their MPs without the option of a by-election, and the irreparable harm to the MPs who would have lost their seats in Parliament in these last few weeks to the 7th December elections, if the meaning put on Article 97(1)(g) by the Speaker was enforced without a clear determination of the disputes around it, this court found it expedient to compel the parties to allow an early hearing rather than make an order that would last only 10 days. This is the reason for the Supreme Court's orders abridging the 14 days allowed for defending a constitutional action through a statement of case and directing the parties to file their respective statements of cases within 7 days and present the issues for resolution immediately thereafter. If the parties had complied with the court's orders, this would have taken all of the 10 days the applicant urges an ex parte order ought to last. Compliance would also have enabled this court to dispose of this case by this week, including the question of whether the suit is competent in form or the jurisdiction of this court has been properly invoked. It is important And the question of whether the jurisdiction has been properly invoked is different from whether the jurisdiction exists. It's a different legal question. It is important to place on record that both the plaintiff and the Attorney General have complied with these orders, and this court is able to complete hearing of this suit if the Speaker chooses to file no processes. For the above reasons, the application is refused.
Yama will be a course for Supreme Court, a Chief Justice at Church, a article named Ama and Otto so Abba. Yere anymore and not a dear no says Speaker at a year in Chenchemui Bay Manasa still na said they are closely parliament no sign at yet to say about Swaba 9 day in Pafufro and I did CBM a rubber son or a Marco like a subscriber like it. I shall read from our form. Within there is some note on my account.